Okay, you can have a seat, and I'm going to try to give you an outline of how a trial unfolds. How many of you have been on a jury before? Oh, just one. Okay, one or two. All right. So most of you haven't. So the only thing you know about a trial is what you've maybe seen in a dramatization in a television program or a movie or something like that. Well, this isn't probably going to disappoint you, because we're not going to resemble probably what you saw in a dramatization movie. First of all, we can't do this in an hour. So that's number one. Your TV show's over in an hour, the trial's done, everything's over with. It doesn't work that way here. As I said, we're going to be here a couple of weeks, so 2 or 3 weeks. So the first thing that we're going to do is the prosecutor is going to present to you what is called his opening statement, in which he will outline his theory about the case. After he gives his opening statement, we'll give the defense attorney an opportunity to make an opening statement at that point. He may decide to make his opening statement then. He may decide to make it at a later point in the trial. But keep in mind that these statements made by the attorneys are not evidence. They're simply designed to help you understand how each side views the case. After the opening statements are made, then we actually start the presentation of evidence. And the prosecutor has announced a number of witnesses that he intends to call, and there will be other items of evidence that are called exhibits. So you'll have basically the testimony of the witnesses, the witness stand is right there, and you'll have exhibits. Exhibits are tangible things that you can pick up and look at, like a document, a photograph, something of that nature. And as each witness is called, the prosecutor will provide the witness with questions, the witness will answer the questions, and then we'll give the defense attorney an opportunity to also provide questions to the witnesses. That's called cross-examination. After the prosecutor has presented his evidence, then the defense may, if they wish, offer evidence, but they don't have to. Remember, I told you by law the defendant doesn't have to prove his innocence or produce any evidence, but if they do decide to call witnesses, then the prosecutor would be given a right to cross-examine those witnesses, just like the defense attorney had a right to cross-examine the prosecutor's witnesses. And because the prosecutor has a burden of proof, he would also be given the opportunity to present any evidence that he might have in rebuttal of the defense witnesses. So after all the witnesses and exhibits have been presented to you, that's the evidence. And the attorneys will be given an opportunity to present to you a closing argument. And like the opening statements, these are not evidence. They're only meant to help you understand the theories that the parties have and how each side sees the case. But you have to base your verdict in the case only on the evidence. Now, you and I have two different roles here in this trial. My responsibility as the judge is to make sure that the trial is run fairly and efficiently, and to make decisions about which evidence can be admitted, and to instruct you, as I'm doing now, on what the law is that you're to apply to the facts in this case to arrive at your verdict. And you have to take the law as I give it to you. Anything I say is not meant to reflect any opinion I might have about the facts in this case, because you are the persons who are going to be deciding the facts. And in other words, your job is to decide what happened. You don't have to worry about what the law is. I'll tell you what the law is. We don't expect you to all be lawyers. We expect you to be jurors with common sense and to determine what the facts are, what happened here in this case. That's what your job is. And that's your job, nobody else's. You're going to have to think about the evidence and all the testimony and decide what each piece of evidence means, how important you think it is for your decision, and of course that includes how much you believe what a witness has to say, and what you decide about the facts in this case is absolutely final. Now, when it comes time to you to decide the facts, you're only allowed to consider the evidence that was properly admitted in the case. And as far as I know at this point, the only thing that is going to be evidence in this case is going to be the testimony of the witnesses, as well as any exhibits that are received into evidence. Now, when you go about this job of deciding what happened or what the facts are in the case, you're going to have to decide in that process necessarily which witnesses you believe and how important you think their testimony is. You don't have to believe everything a witness says. You don't have to reject everything a witness says. You're free to believe all of it, or none of it, or just parts of it. And in deciding which testimony you believe, this is where you come into play here as jurors. You're not lawyers. We don't expect you to know the law, but we expect you to use your common sense and everyday experiences. However, in deciding whether you believe a witness's testimony, you shouldn't consider anything related to that witness's national origin or race or gender or anything like that that has nothing to do with a person's believability. Now, there isn't an algorithm, there isn't a fixed set of rules that I can give you for determining whether to believe a witness or not. There are some questions you might ask yourself as you're evaluating a witness. Things like, was the witness able to see or hear clearly the event they're talking about? Was there anything else that was going on at the same time that might have distracted the witness from the event they're testifying about? How long did they observe or listen to this event? Does the witness seem to have a good memory about what happened? How does the witness look and act while testifying? The witnesses are going to be right here. This is the witness stand, so you're going to be able to observe the witnesses. How do they look and act while they're testifying? Do they seem to be making an honest effort to tell the truth, or are they evasive or argumentative? Is there anything about a witness's age or maturity that would impact their believability? Does the witness project any bias or prejudice or personal interest in how this case is ultimately decided? Has the witness been subjected to any promises or threats or suggestions that might influence their testimony? In general, does the witness have any special reason to tell you the truth? Or for that matter, does the witness have any special reason to not tell you the truth? And all in all, how reasonable does the witness's testimony seem to you when you put it in the context of all of the other evidence in the case? Now, the way we go about this process of presenting the testimony of a witness, as I told you, it's a question and answer process. The attorneys ask questions, the witnesses respond to the questions. Keep in mind that the questions themselves are not evidence. It's the answers that the witness provides to the question that provides the evidence. So you shouldn't think that something's true just because one of the attorneys asks a question that assumes or suggests that it's true. Now, it's possible I may ask a question or two of a witness. If I do that, I'm not trying to reflect any opinion I might have about the evidence in the case. If I ask a question, my only reason for doing that would be to explore something that hasn't been fully explored through the attorneys. Now, we have a certain set of rules that are provided in the law as to how a trial can be conducted. And that also governs what evidence can be admitted and what evidence cannot, and what evidence can be considered by you in your decision and what cannot be considered by you. And the attorneys are well trained in those rules. I have about 35 years of experience at this, so I've got some idea how this is supposed to go. But if one of the attorneys feels one of those rules is not being followed, it's their obligation to their client to bring that to my attention, and the way they do that is through what is called an objection. And you will hear the attorney say, objection, Your Honor, and then they'll tell me why they think one of the rules is not being followed, and I'll give the other attorney an opportunity to present his view of that, and then I'll have to make a decision. And I have to make that decision according to the law, so my rulings for one side or the other are certainly not meant to reflect any opinion I might have about the case. I have to make those rulings according to the law. Now, the rulings that I make, most of the time I can make those rulings fairly quickly. Like I say, I've been doing this for over 35 years, and so I know I've got a pretty good idea how we're supposed to do this. But sometimes we might have an issue brought up in one of these objections that require a little more discussion with the attorneys. I may have that discussion with them right here. I may decide to have that discussion with them. You've already seen that a couple times here where I have a discussion with them over here. And sometimes, if I think it's going to be a protracted discussion, I may excuse you back to the jury room while I continue with that discussion with the attorneys and do any research that I think I need to do to correctly and properly respond to the objection. Now, if we do have that discussion over here, or we excuse you back to the jury room, when we do that, we're not trying to hide something from you. But what we're dealing with is a question involving a legal issue. And remember, I told you, your job is to decide the facts. I'll tell you what the law is. So when we have a question regarding the law, there's no use binding you up with all the arguments involved in that. You got enough to be concerned with in this case in deciding the facts. You don't need to be concerned about decisions we're making on what the law is in this case. So we simply have that discussion out of your hearing to not burden you with that. As I say, we excuse you back to the jury room if it's going to be protracted, just to give you a break. That's all we're doing. So we're not trying to hide something from you, but we're dealing with matters that you don't have to be concerned with. You need to be concerned with determining the facts. I will determine what the appropriate law is to be applied here. Now, I've already cautioned you not to have any discussion with anyone involved in the trial, and you're not to have any discussion with anyone about the case, even if they're not involved in the trial. And so when it comes time for you to actually decide the case, I'll tell you when that time is, and then you'll go back to the jury room and you'll be able to discuss it among yourselves at that point. And of course, when the trial's over with, you can talk to anybody you want to about this case. You don't have to, but you can if you want to. But until we reach that point, you're not to discuss the case with anyone. And as I said, if you have any problem with someone pressing you about wanting to talk about the case, let the bailiff know, and we'll make sure that you're not subjected to that any further. Now, it's very important then that you have the only information that you get about this case is that which you get here in the courtroom when you're acting as the jury in the presence of me and both sides in the case. And so I've already cautioned you, you're not to listen to or read or consult with any media accounts of this event from this day forward. That's over with. When the case is over with, you can, as I say, read anything you want, but we're not there yet. We're a few weeks away from there. So that's something that you have to not be involved in. You're not allowed to visit the scene of this event. You're not to conduct any experiments of your own or do some kind of research on the internet or anything like that. None of that is evidence in this case. And you're only allowed to consider the evidence in this case. And there's a reason for that, because evidence can only be submitted when it meets the test of the rules of law. And that's what we're here for. This is a legal proceeding. This is not a media event. This is a legal proceeding, and it's going to be conducted on that basis. And that's how you need to conduct yourselves. And that's why we prohibit you from doing any of those other things. Now, there was a question in the case about wanting to take notes. I think it was you had a question about that. If you wish to take notes, let us know. We'll provide you with a pad, pencil to take notes. However, those notes will be retained here by the court, so when we break for noon hour, those notes need to be turned in the jury room, and the bailiff will keep them in his custody. When we adjourn for the evening, we will keep those notes in our custody, and when the case is over with, those notes will be destroyed. So if you do want to take notes, you need to let the bailiff know, and he'll provide you with what you need for that. I just want to caution you about this, though. I do that reluctantly. I usually don't let jurors take notes, and I'll tell you why. Because it's going to distract. It has a tendency to distract you from paying attention to what the witness is saying. You're so absorbed in trying to get everything down that you're not paying attention to the witness. And so if you want to take notes, okay, but keep in mind, the idea here is to listen, to
look at the witness, to listen to the witness, and make your decisions about the believability of the witnesses when they're testifying. When you're taking notes, you're distracted from that. You can if you wish. I'm just warning you about that. So anyway, let the bailiff know about that. Now, you notice we have 14. And if you know anything about trials, you're thinking, well, wait a minute, I thought it was 12. Why do we have 14 here? Well, I told you all yesterday this trial is going to be about 3 weeks long. And everybody said, okay, I get it. I can be here for the 3 weeks. But, I don't know what's going to happen over these next 3 weeks. There might be something, an emergency of a critical nature that comes up in somebody's life, and we may not be able to keep you here. Hopefully that won't happen, but obviously we don't know that. And so that's why we have a couple extra jurors in case that crisis moment happens, and hopefully it won't. All right? Because if we get down below 12 jurors, then we have to abort the trial, and we don't want to have to do that. So that's why we have a couple extra jurors. Now what's going to happen is, after we have reached the end point of the case where we're going to turn the case over to you for your deliberations, we're going to randomly just put everybody's number in a box and draw a couple of numbers out, and those 2 jurors will be excused from deliberating in the case, and the 12 of you who are remaining will go back. Now, there's no use sitting back and saying, well, I don't have to worry about this because we're going to kick 2 people out of here anyway. Well, the chances of you being that person is 1 in 7. So chances are you're going to be on the jury deliberating, so don't operate on the assumption that you're going to be excused. We don't know who that person is. It's going to be done randomly. You all need to pay attention. Somebody asked, one of the jurors, I don't think it was one of you that's left, I think somebody was excused, feel uncomfortable about consequences to someone who's in a trial if they're convicted. As I told that juror, that should have no influence on your decision in this case, because that's something that falls on me. When someone is convicted of an offense, then I have to impose a sentence. You play no role in that whatsoever, so don't be concerned about that. I may give you instructions during the trial. I will be giving you some detailed instructions after all the evidence and the arguments have been completed. And you should consider all of my instructions. They form the body of law that you use to arrive at your verdict. So after all the evidence has been presented and the lawyers have given their arguments, I'll give you those detailed instructions. And by the way, everything will be in writing, all these instructions, including what I'm telling you now. You'll have written copies of that, so you don't have to worry about memorizing all this. You won't be doing a test to see what you remember about this. You'll have written instructions. But after we do give you those detailed instructions, and then I will tell you it's time to go to the jury room. It's time to deliberate and decide the case. Now, this is a criminal case, so if there's going to be a verdict, it has to be unanimous, and that means that every juror must agree on it, and it must reflect the individual considered judgment of each juror. So it's important for you to all keep an open mind and not make any decision about anything in this case until you've heard everything and had an opportunity to observe everything. Now, I read to you when we started the case that document, you may recall, that was called the information, which are the charges. And there are 2 charges in this case, but the first charge encompasses more than one possibility. So the 2 charges in this case are open murder, it's called open murder, and felony firearm. And Mr. Willis has pled not guilty to both the charge of open murder as well as the charge of felony firearm. So I told you that there are elements that have to be proved by the prosecutor for each of these charges. And to prove the charge of murder, the prosecutor has to prove beyond a reasonable doubt certain elements. Now, open murder gives you basically 3 options to consider. One is called first-degree premeditated murder, another is called first-degree felony murder, and another is called second-degree murder. Now, to prove first-degree premeditated murder, the prosecutor has to prove first that Mr. Willis caused the death of Rebecca Bletch. That is, that Rebecca Bletch died as a result of the defendant shooting her with a gun. And second, the prosecutor has to prove that Mr. Willis intended to kill Rebecca Bletch. Third, the prosecutor must prove that his intent to kill was premeditated, that is, thought out beforehand. Fourth, the prosecutor must prove that the killing itself was deliberate, which means that Mr. Willis considered the pros and cons of the killing, thought about and chose his actions before he did it. And there must have been real and substantial reflection for long enough to give a reasonable person a chance to think about twice about the intent to kill. And the law doesn't say how much time must elapse. It's for you to decide if enough time passed under the circumstances of this case, and the killing cannot have been the result of a sudden impulse without any thought or reflection. Now, in addition to first-degree premeditated murder, you may also consider what is called first-degree felony murder. And to prove that charge, the prosecutor has to prove the elements beyond a reasonable doubt as follows. First, he must prove that Mr. Willis caused the death of Rebecca Bletch, that is, that Rebecca Bletch died as the result of Mr. Willis shooting her. Second, the prosecutor must prove that at the time, Mr. Willis had one of three states of mind. Either he intended to kill, or he intended to do great bodily harm to Rebecca Bletch, or he knowingly created a very high risk of death or great bodily harm, knowing that such death or great bodily harm would be the likely result of his actions. Now, the third thing the prosecutor must prove for felony murder is that when he did the act that caused the death of Rebecca Bletch, he was committing or attempting to commit or helping someone else commit the crime of kidnapping. And for the crime of kidnapping, the prosecutor must prove beyond a reasonable doubt, first, that Mr. Willis knowingly restrained Rebecca Bletch. Now, when we say restrain, we mean to restrict a person's movements or to confine the person so as to interfere with that person's liberty without that person's consent or without legal authority. And the restraint doesn't have to exist for any particular length of time. It may be related or incidental to the commission of other criminal acts. Second, for kidnapping, the prosecutor has to prove that when the defendant did so, he intended to do one or more of the following things. Either hold that person for ransom or reward, or use that person as a shield or hostage, or engage in criminal sexual penetration or criminal sexual contact with that person, or take that person out of the state, or hold that person in involuntary servitude. Now, in addition to that charge of first-degree felony murder, you may also consider the lesser charge of second-degree murder. And to prove that charge, the prosecutor must prove beyond a reasonable doubt, first, that Mr. Willis caused the death of Rebecca Bletch, that is, that Rebecca Bletch died as a result of Mr. Willis shooting her with a gun. Second, the defendant had one of those three states of mind, that being he intended to kill, or he intended to do great bodily harm to Rebecca Bletch, or he knowingly created a very high risk of death or great bodily harm, knowing that death or great bodily harm would be the likely result of his actions. Now, the second charge in this case is called felony firearm. And to prove that case, prosecutor must prove beyond a reasonable doubt. First, that Mr. Willis committed or attempted to commit the crime of murder, which has been defined for you. It's not necessary, however, that he be convicted of that crime. Second, the prosecutor must prove that at the time that Mr. Willis committed or attempted to commit that crime, that he knowingly or carried or possessed a firearm, and a pistol is a firearm. Now, I think that's all you need to know at this time to be able to sit back and listen to the evidence in this case.